Hello, everyone. So we are beginning with the today's session. Good morning and good evening, all of you. A very warm welcome to one and all present here that are a part of this webinar. I thank you all for sparing your precious time and being a part of this webinar, organized by markpattern.org and sponsored by HK Acharya & Company. I am Surbhi Derasari.
And I am Niyati Fatehpuria, your host for this webinar and a part of markpattern.org. We cordially welcome you all. Today, we have gathered to share our knowledge and ideas with accomplished speakers from diverse backgrounds from all over the world.
Now, I would like to give a brief introduction about our organizers and co-organizers. markpattern.org. markpattern.org, established in 2004, is actively associated and dedicated to the support and advancement of intellectual property elements. The main object of the organization is to provide in-depth understanding and to create awareness of intellectual property rights among attorneys, advocates, professors, law students, and also among manufacturers, industrialists, traders, and the general public. markpattern.org undertakes various activities at local, national, and international levels by organizing trade fairs, exhibitions, seminars, lectures, and study circle activities to propagate the knowledge of the intellectual property laws to the layman, thus creating awareness, developing recognition, and acceptance of the intellectual property rights.
Institute of Law, Nirma University. Founded on the vision of Padma Shri Dr. Karsan Bhai Patel, the Institute of Law, Nirma University, embodying the principles of justice, education, excellence, and professionalism that imparts quality legal education and has produced a new generation of lawyers, leaders, policymakers over the years.
University School of Law. The University School of Law in the Gujarat University was established in 1977. It is one of the highest ranked law college, not only in Gujarat, but also occupies a top spot in the ranking at the national level. It offers a 2 years full-time LLM course in IPR.
Xavier Research Foundation. The Xavier Research Foundation Trust runs the Loyola Center for Research and Development, an autonomous institute which was established in the year 1987 in St. Xavier's College, Ahmedabad. Its goal is to do research in science and technology and the humanities. The center not only employs scientific staff dedicated to research, but also provides infrastructural support and expertise to students working on frontline research fields in environmental microbiology and plant biotechnology. The mission of the center is to target grassroots communities on the fringes of our economy and through innovation, entrepreneurship, training, and handholding, set up production units at medium, small, and micro levels.
ICFI Law School, Hyderabad. The Faculty of Law, commonly known as ICFI Law School, is a constituent unit of the ICFI Foundation for Higher Education, located in the lush green environment in the vicinity of historical city of Hyderabad. The ICFI Law School, with excellent and continuous teaching and learning process, student-centric and industry-friendly dynamic curriculum, and real-life exposure, provides best-in-class legal education to the students and carving them to market-ready legal professionals out of mediocre students who desires of making law as the dream career. The ICFI Law School offers undergraduate programs, postgraduate programs, doctoral programs, and certificate programs. All the undergraduate programs offered by the ICFI Law School are approved by the Bar Council of India, and the other programs are in accordance with the UG forms.
LD College of Engineering. Lal Bhai Dalpat Bhai College of Engineering, Ahmedabad, is a premier government engineering institute in Gujarat, set with the objectives of imparting higher education, research, and training in the various fields of engineering and technology. The institute is affiliated to Gujarat Technological University, Ahmedabad, and administered by the Department of Technical Education, Government of Gujarat. LD College of Engineering was established on 20th June 1948 as one of the first few engineering colleges in India.
USIIC. USIIC, that is the US India Importers Council, is a not-for-profit initiative started by a group of Indian SME importers responsible for imports of over $1 billion from USA. It is the only exclusive importers council in the world. USIIC acts as an intermediary organization to facilitate partnership and trade between Indian and American business, thus acting as a catalyst in promoting economic growth between the United States and India.
Rotary Club of Ahmedabad Elite. The Rotary Club of Ahmedabad Elite formed in 2010 and following the footsteps of its highly acclaimed parentage, is dedicated to humanitarian service, high ethical standards, goodwill in the community, and peace in the world. It brings together dedicated individuals to exchange ideas, build relationships, and take action. It supports humanitarian cause by coordinating programs, campaigns, and initiatives, be it free eye and dental checkup camps or distribution of basic necessities to victims in flood-affected areas, to name a few. The Rotary Club of Ahmedabad Elite has always been quick to respond to urgent and pressing needs of the society by swinging into action on a war footing whenever the situation has warranted it to.
Gujarat Technological University. It is in the fields of engineering, architecture, management, pharmacy, and computer. Is a premier academic and research institution which has driven new ways of thinking since 2007 funding, established by the government of Gujarat. Today, Gujarat Technological University is an intellectual destination that draws inspired scholars to its campus, keeping GTU at the nexus of ideas that challenge and change the world. GTU is a state university with 486 affiliated colleges in its fold, operating across the state of Gujarat through its 5 zones at Ahmedabad, Gandhinagar, Vallabh Vidyanagar, Rajkot, and Surat. The university has about 4 lakh students enrolled in a large number of diploma, undergraduate, postgraduate programs, along with the robust doctoral program. I once again thank our organizers and co-organizers.
Now, moving forward, we would like to welcome our esteemed dignitaries from across the world. First and foremost, trustee at markpatent.org and executive director of HK Acharya and Company, Mr. Omkar Acharya.
Principal at Foundry Intellectual Property from Australia, Mr. Lester Miller.
Patent attorney at TriPatent, Germany, Dr. Engineer Jörg Wagner.
Managing partner, patent attorney at IP March from China, Mr. Stephen Yang.
Partner of Promark Law Firm from Paris, Ms. Elizabeth Berthe.
Patent agent at HK Acharya and Company, Mr. Nitin Patel.
We warmly welcome all of you. So now we would move on to our welcome address from Mr. Omkar Acharya along with a small introduction. Omkar Acharya is a trustee of markpatent.org and the executive director of HK Acharya and Company. Mr. Acharya is a renowned trademarks attorney and a member of the Bar Council of Gujarat. Mr. Acharya has a bachelor's degree in science from St. Xavier's College and a bachelor's degree in law from Gujarat University, after which he pursued a master's in science in biotechnology and bioinformatics. He is a skilled manager with the ability to lead and motivate by possessing great communication skills, and he takes a holistic approach in managing companies' domestic and international operations. Mr. Acharya is a member of various well-known IP associations, namely INTA, ECTA, BIO, AIPPI, APAA, and is also a corporate member of the United States India Importers Council. With a young and dynamic approach, Mr. Acharya is a leading international operation and taking the company to greater heights at both levels, nationally and internationally. So now I request Mr. Omkar Acharya to deliver his welcome address.
Over to you, sir.
Thank you so much, Niyati and Survi. So yeah, good morning, good afternoon, and good evening to one and all present virtually from around the globe. On behalf of markpatent.org, I would like to welcome all the speakers from different countries, as well as the audience from different parts of the world. The theme of today's webinar, that is Engineering Advanced Concepts of Patenting, has been very aptly set, as now there is such an exponential growth in the field of engineering, especially after the pandemic. Innovations are taking place at a very minute level, and the manufacturers are willing to stand different from other companies, but in a more economical and innovative way. And what else can be the way for being economical and innovative without getting that patented? The innovations are done not only on the basic engineering side, but in a multidisciplinary way through biomedical engineering, or maybe you can say computer engineering, chemical engineering, and whatnot. I would add maybe artificial intelligence also as an advanced concept of engineering, which is solving unimaginable problems. Such interdisciplinary engineerings can also precisely do operations for several treatments for patients that are being done by robots. So that is something really amazing. It is so hard to predict what shall happen tomorrow. looking at the pace at which science as a subject is developing. On this note, let us get answers to our questions solved by our eminent speakers and my friends. Let me welcome Lester Miller from Australia, Dr. Wagner from Germany, Stephen Yang from China, Elizabeth from France, and due to some unavoidable circumstances, Mr. Eldakak from UAE could not join us today. Let me tell you, all the speakers are highly proficient in their fields, and we all shall be learning a lot from their experiences, their knowledge, and their wisdom. Mark Patent has always taken care to safeguard its motto of being a knowledge hub, and the speakers here are the proof of it. Also, please allow me to welcome the representatives from our co-organizers, Xavier's Research Foundation, Nirma University, Gujarat University, ICFAI Law College, Gujarat Technological University, LD College of Engineering, and from industrial associations. Let me welcome the representatives from USIIC and Rotary Club of Ahmedabad, and also the sponsor of the webinar, HK Acharyan Company. Lastly, let me welcome all the audience present here virtually, which I can see are from different parts of the globe also. I welcome you all. Let us begin the marathon of knowledge. Thank you. Over to you. Thank you.
Thank you so much, sir, for this enlightening introduction and for setting the tone for the webinar. This session will have series of panelists in the subject matter, engineering and advanced concept of patenting. Now, let me introduce you all to our first speaker of this session, Mr. Lester Miller, who commenced his career in designing and testing passenger trains and locomotives. 20 years ago, he switched gears and started an impressive career in IP law, and since he has drafted and prosecuted patent applications for local and multinational corporations in areas as diverse as surfboards to remote power supplies to underwater turbine arrangements. He has patent specifications that he drafted, poured over in federal courts, and emerged victorious. He is knowledgeable in patents, designs, and trademarks and will lead us in an interesting discussion. Over to you, sir.
Good evening. Well, first of all, I'm going to bring, I'm looking forward to bringing you a few interesting developments and advanced concepts in, oh, my apologies, in engineering patents. And I'm going to share my screen. First of all, I wanted to show you, hopefully you can still hear me. I'm looking forward to, first I'm going to speak on ownership, who owns what, and then design patents, protecting the shape of a new engineered product in Australia, and then digging into exactly how to avoid falling into the trap of lack of patentable subject matter if you have a computer-related invention. The more I advance in my career as a patent attorney, the more I'm approached to resolve an ownership dispute between the inventor and the commercialization vehicle after things have gone sour. So while it does seem a little bit basic, it's so important that I thought it was useful to mention it now. When I did start in the profession 20 years ago, I almost barely thought about inventorship apart from when the ownership, I should say. I didn't think about ownership much apart from when the Patent Office stopped the grant of a patent because I still had the application in a business name which has no legal personality. So now we won't proceed to file without having assignments or employment contracts reviewed and on file, or the lawyers have reviewed them and there's been agreement. So the basic principle in Australia has been set since University of WA and Gray, where it was set out that patent ownership boils down to what a person is employed to do. If they are employed to invent, then the employer owns the invention. But if not, it's much harder to prove that the employer should be the owner. Is there a job description? What does it say? This is often of assistance, but it's not always decisive. Sometimes policies help, but they're not always helpful. Sometimes directors of companies have special responsibilities to assign the rights to the invention to the company. But in the absence of an assignment, and if the patent for the technology was applied for before the company came into being, it is somewhat arguable. What can you do? make sure that assignments are executed early, at least on filing or before the filing is done, when everyone is in the honeymoon phase. So before someone comes on board, take the time to define their role and what they are there for. It can be very useful and save a lot of time. Now, I'm going to move on to a happier topic. And that topic is going to be design patents. So less combative. Australia finally has in place a grace period for design registrations. Now, as you know, design patents protect the appearance of an engineered product. There are about 35,000 patent applications filed in Australia every year, and there were 8,200 design applications filed in the same year. So maybe a quarter as many. Still, they're growing in number every year. It can be irritating or infuriating when an applicant has relied on the grace period in another country to file there, and then they go to Australia to seek similar protection. But until 10th of March 2022, 6 weeks or so away, you still can't do that. So on that date, Australia will disregard the earlier publication of a design up to 12 months prior. There is a prior user defence, so of course we just don't recommend that you rely on it as a matter of routine, but at least it's there if you need it. If someone sees your invention and they start to take steps to use it in Australia, that person can do it for the rest of their lives. So it can ruin your monopoly entirely. So you have to share it with someone else. Interestingly though, if the EPO, for example, publishes the design, the grace period doesn't apply unless you use the convention properly, unless you use the convention period properly. So the convention period must be still observed or we can't help. Some other headlines that are some definitional things. Expert decision maker in Australia has changed to someone who doesn't necessarily have to use the design to have an opinion on its newness. An innocent infringement is okay if it's done before publication, and an exclusive licensee can use it. Now to the real patent stuff. Australia had a very flexible approach for decades to patentable subject matter. We had a very permissive approach to patent filings. We used a case called the NRDC, where the High Court said there was to the lay mind a sensational advantage in spraying a herbicidal chemical on a crop to increase the yield, and that was patentable. All we needed was an artificially created state of affairs of economic utility. There were some things excluded, of course, they're on the screen, they are shown. The collocations, you know, the pen with a watch, say, the fine arts, ideas, schemes, you know, those things were always excluded from patentability. But a computer was all you needed in 1991 when IBM used a mathematical formula in a computer to draw a nicer looking curve. But after that, it became a bit harder. We needed more than a conventional use of a computer. And we had a case called RPL Central. There was a method of pre-pending questions for recognition of prior learning assessment. So the computer would pre-pend, have you ever, in front of a bunch of questions, in front of a bunch of syllabus requirements. So for a nurse, you might say, have you ever lifted a person off a bed? Have you ever, provided medicines? That kind of thing. And so the have you ever part would prepend to the provision of medicines, and then somebody would answer those questions. But then the problem was a person would then assess the answers. So it was just seen as a conventional use of a computer, because all the computer did was add those three words in various different ways to the syllabus requirements. Conventional use of a computer. If there was some sort of computer assessment, there might have been patentable, but not good enough. So the full federal court in November 2021 handed down its latest decision. And again, the court saw the claim as claiming a use of a computer and not particularly advancing computer technology. It was a gaming machine. The claim was to a gaming machine, which was so far so good. But because the reason being was because that's sort of a bit more concrete, a bit more technical, having something physical at least. But the claim was rejected, and I'll tell you why in a minute. But the computer specialist patent attorneys may throw their hands up in the air and throw the towel in, because the claim wasn't just a method of doing some standard things using software. The claim was for a gaming machine. But the devil is in the detail. That is, all the features of the gaming machine, the display, the random number generator, the credit input mechanism, the game controller, they were standard and well known. And the court found that that was just a computer, nothing more. Even though the applicant tried to argue that there was some regulation involved, made it much more complicated, not good enough. The new features were to a free game. It was a free game that was triggered by the game controller, which was looking for certain conditions of gameplay. So monitoring the game, something happens, new game triggered, free game triggered. And then the free game set up and then played on the screen while the other game was paused. And then the player was awarded the credits for winnings on the free game. But that was just it was claimed just like that, really, and in fairly conversational language. But that was just considered to be an abstract concept for that reason. And there's nothing in that feature of the free game in the other game that improved the computer. So the applicant argued that the free game improved the player's enjoyment, but there seemed to be nothing in that part of the claim specifically directed to the player's enjoyment. The programmer had nothing in the claim to program about that sort of thing. There's nothing in the claim that said the programmer should be doing something about players' enjoyment. So what can we do? The court left open many different claims. There's a two-part test. The original federal court, the first instance judge was wrong. He asked, was the claim for a mere business scheme implemented in the computer? He said no, so it was okay. And he didn't bother answering the second one, which was, did the invention lie in the manner in which it had been implemented? This latest test was an appeal. So the full bench said, look, the proper test really is the invention a computer implemented invention? Yes. And if so, can it be described as an advance in computer technology? No, it's just a use of computer technology, not really doing much. It's just there's no advance in computer technology. There's no advancement in the technology, just the use of it to implement an abstract idea. So we need to provide something more concrete to avoid it being a computer implemented invention, something that takes it into the real world perhaps. And that thing has to be defined in the claim, of course. In this case, the computer itself wasn't enough. The display, the credit input mechanism, even so, not concrete and not new enough. And the judges were aware that they might be overlapping manner of manufacture with novelty, but they stayed firm. They say, give us something else. Now, without rushing on too quickly, I would like to hand over, though, to Dr. Wagner.
Okay, thank you very much, Lester.
Thank you, Mr. Lester Miller, for your informative presentation. On to our second speaker for the evening, Dr. Engineer Jörg Wagner, patent attorney at Trademark, Germany. Dr. Wagner completed his mechanical engineering in 2003 from University of Technology at Darmstadt and then earned his PhD in the same field with first-class honors in 2009. Making excellent use of his scientific aptitude and insight, Dr. Wagner enrolled to become a patent attorney, after which he became a part of the team at Trademark. His great skill and expertise in the field resulted in him becoming the single owner of his firm in 2013. Over to you, sir.
Hello to everybody. Thank you very much, Mr. Omkar Acharya. I hope I give it correctly. And thank you very much for the introduction, Zohabi and Niyati. May you start my slides? So there are coming my slides. Thank you very much. So I want to bring some IP news from Germany to you, and want to introduce my little office. As already told to you, it's 10 years, around 10 years ago, I started. And since 1 year, I'm working together with Mr. Hagebering, an IP lawyer. So we are working together because a patent attorney is, in some cases, not enough for our clients, because we want to do more than just bringing registered rights for the clients. We want perhaps to start earlier, giving know-how protection. And that's the first point where I want to get some more details for you. The second subject will be artificial intelligence. And the third will be, the third will be some news like PCT period. You may file in some months 31 months instead of 30 months when you come from PCT to DE. So you can now switch to the next slide, please. So know-how protection is an important addition to patents and needs to start early. If you, as inventive teams, you're working together with other companies or other free inventors, you always need to care for not losing your intellectual property rights to the others, or as a group to third parties. So you need to be quite careful, and it should be from the beginning on a subject to inventors, to engineers, but also to just groups talking about a new business idea, business concept. So at the beginning, do not so much care about will it be worth a patent or not? Will there be some design claim later on also? It's the ideas will be present suddenly sometimes, and you need to have some good routines to get your ideas saved, so that later on you can say, okay, this part of the idea is from the one person and the other part of the idea is from the second person, with the name and the company, this and that. This is very important. It came to Germany or to Europe over activities of the countries China and USA. They had some new rules for getting business secrets in a trade secrets directive at the end into the EU, and this is 2 years old now, and also is implemented in the UK. And I noted here in this slides, because I need to be ready in 15 minutes already now. You have some links there in the slides, and you may click to the slides, and as I'm informed, you will receive the slides later on, and be able in the PDF document we sent to the conference organizations. Then you markpatent.org will care for so that you will be able to click the hyperlinks. So you please be aware when you're inventing that you have some not only NDAs, but care for write into the NDAs some concrete information about what is the NDA caring about, what is it dealing, not only type in the two names of the participants. So then you may perhaps enter into next steps if you are developing artificial intelligence patents, for example, or you are doing some business models and just at the end the computer is helping to realize it. There is not always the possibility to patent in the end something. So be careful with the know-how and take care for all the details you need to know if you to work according to the directives that is linked before. And why did we the best to learn is get an overview. Where are you? And switch to the next slide, please. So there's some kind of yes, you can read groups and if you are in a certain group, patent attorneys will give you some hints how to get drafted a very good patent application, but it is really depending which kind of subject do you have. We cannot say all these kinds of newer inventions have to be filed as a patent application always in the same way. It depends what it's really working. And there are very specialized patent agents. And I've given you some where I think they really will be able to file very good patent applications in Europe. And you can find some publications, again, with some links I share here with you. So you can switch to the next slide because it will not be possible to give an introduction how to write very good computer implemented patents today. If you feed some patent attorney, how can you help him how can you prepare something for him? It is really important to have a very good full specification to get them start something. And if you generate, for example, some lists like you would try to order some IT specialist to get your software running. So these are the lists. What should come out of the machine or the software, which the patent attorney also needs. So the full specification in the beginning will be worth so that the attorneys are not too expensive. And another thing is really of very, very great importance to get quite early some helpful searches also. So a patent application, and this is something you might think normally you filed in analogous systems, you filed patent applications to get a monopole right in the end. But in these times, I think most often for the computer implemented inventions, it can make sense just to file it as a kind of searching order and to get an overview who could have some similar patents already running. to reduce your risks as a developer, and therefore be careful and make very good explanations to the searcher in the patent office. Also, he needs to know what will be perhaps a claim, not just because you will have a monopoly on it, but he needs to know your idea to provide you with a good search on your topic. So this will be helpful for you. Then next slide, please. Just some thoughts of other colleagues coming to our subject, intellectual property and digitization. There is some very famous office, Dennemeyer, doing lots of IP consulting, and they found that that even the pandemic is helping out to overcome some bad paper structures of patent attorneys and IP systems. Also, the offices perhaps woke up a little bit with the help of Corona, perhaps, and we have a lot of changes there at the moment. But it needs to go on, even if we hopefully overcome these pandemic times. And I think it will. So be if you want to get always some good news, you can use the newsletters of Dennemeyer, for example, to stay ahead. Next slide, please. The news of from Germany and from Europe, as promised in my timetable, it is now to say that there will perhaps really be the EU unitary patent in the end of this year. That's where people from the world are looking on, and it seems to be. You have an actual snapshot from the EPO homepage here with the countries that participate in the unitary patent. You see that there are actually 17 countries already signing, but it will never be the 38 states that are reachable over the European patent. So it will be perhaps interesting to reach some of these states by taking the unitary patent, but you should know that you do not never will reach all of them in future by taking this new possibility. More of these informations are again given by this actual link at the bottom of this slide. Next slide, please. So, and here we are reaching the end of my slides. We have some news of the president of German Patent and Trademark Office. She presented in last year a reform package and said that we would in Germany strengthen our outstanding position of our country as location for intellectual property protection. Yes, we are always working on it, but I think in the field of in the new technology fields, it is a really hard competition between the attorneys around the world and between the offices around the world to get at the end really good system working for the technology developing people and for the users as well. And I hope we do not stay in country by country, but work together. And I'm very happy that we share our knowledge today, and would be happy if you come back to me and in some groups together to talk about subjects like that in the next years, to develop our knowledge without borders. So next slide, please. If you then get some more links, then you can go deeper into these subjects, how to get very good patents drafted, and how you perhaps can get very good patents drafted in artificial intelligence, or even just follow Mr. Best, who's really one of the leading German patent attorneys, European patent attorneys in these kind of digital transformation patents. It's really very interesting to follow him, to read from about our new topic, and have a lot of fun with it, and be open to learn. I like to learn a lot about it more, and thank you to follow my slides.
Thank you so much, Dr. Wagner, for this wonderful presentation. So now moving forward to our next speaker, I am much delighted to introduce to you Mr. Stephen Yang, who is practicing in IP firms in China as a patent attorney and managing partner of IP March. Mr. Yang practice covers patent drafting, prosecution, invalidation, opinion, and litigation in mechanics, electronics, energy, and high-tech areas. In addition, he once worked in-house in Canada. Mr. Yang's technical background is mechanical and industrial engineering. He received his double bachelor degrees from Tsinghua University in China and a master degree from University of Toronto in Canada. Mr. Stephen is a frequent speaker at international conferences, webinars, and courses, and a prolific author of many articles and books. In particular, he is the lead author of the book IP Protection in China. Mr. Stephen has been consistently recognized by various sources as a leading IP practitioner in China. Over to you, sir.
Okay, thank you so much. Let me first share my screen. Can you see it?
Yes, we can.
Okay.
Yes, sir.
Okay, perfect. So today I'll be giving out China patent prosecution tips. So we'll dive right in. So the basics for patent practice for us as Chinese patent attorneys are these. We have a patent law, which has a latest version that took effect on June 1st last year. Then we have more detailed rules. We call that implementing regulations. The last one was published in compliance with the earlier version of the patent law. But then because we have a new patent law, we need to have a new implementing regulations. But we don't have that yet. And the reason for that is there is a whole new chapter directed to the Hague Agreement. China is getting ready to join the Hague Agreement for designs, but that has not happened yet. So I think we need to wait for that to happen to have our final version of the new implementing regulations. In addition to those, we have guidelines for patent examination. Again, because there's no new implementing regulations, the guidelines for patent examination has not yet been finalized either. We only have a draft version. In some of my talks, I will talk about the proposed changes in the draft implementing regulations. And so these are all codified laws and regulations But there is also an additional thing we call it judicial interpretation. These are issued by the Supreme People's Court. Again, is in article format, Article 1, Article 2, but it is a summary of sort of a guidance given to legal practitioners and courts at lower levels. So when they're faced with certain circumstances, what should they do? It's more like tests to given in case laws. Like, for example, how should you compare the novelty of a design, infringement of a design, things like that. These will all be given in judicial interpretation, and there are lots of them. And in recent years, the Supreme Court had issued a good number of these. So sometimes it's very hard to people from other countries to follow. Some basics about patents in China. We have 3 types of patent. We have invention patent, which is a regular patent. It's valid for 20 years. We have utility model, which is valid for 10 years. We have a design patent. It's also called design patent, like in the US. It's valid for 15 years. So if you file your design application on June 1st or after, your term will be 15 years. Before that, it will be 10 years. All the patent terms are counted from the filing date. Patent term extension is available for new drug patent. Patent term adjustment is also available. But keep in mind that a Chinese patent is only valid in mainland China. And that means Hong Kong, Macau, and Taiwan are not covered. These are separate jurisdictions. So this is a patent application flow chart for those of you who are not familiar with filing in China. I will go through this very briefly. So first of all, you file the application, and then there will be a preliminary examination, more like formality examination, but not quite. The red lines are for invention patent, the regular ones, so I'll go through those first. First, you need to pass preliminary examination, and then the application will be published. This will be around 18 months. And then anytime from the earliest priority date within 3 years, you could request for examination, and then it will enter substantive examination stage. An application will not enter substantive examination stage if it is not published. So it is not possible to have an application examined before it's published. So that is certain in China. Then after substantive examination, you get your application either issued or rejected. If it's rejected, you can request what we call re-examination. This is a term that is different in meaning from the US term. You file this request at the patent re-examination in the invalidation department, and then their decision is appealable to court, always to the same court, Beijing IP court, as a first instance. And then its decision can be further appealed to a second court, which is the IP tribunal of the Supreme Court. Some say IP court of the Supreme Court. So these are for the inventions. For the green lines are for utility model or designs. So you file it, no substantive examination is needed. Only preliminary examination. The reason I don't call it formality examination is that it is not just formality examination. For utility model, they examine the claim language. They examine the subject matter. For utility model, you can only protect product. You cannot protect method or use. You cannot even include method features or use features in the claim language. They examine all that and some additional things. I'm not going to elaborate. For designs, they will examine very closely the drawings. You need to have 6 direct views corresponding to each other, meeting the mechanical drawing making standard in many aspects. So you sometimes need that mechanical background to understand why this application is being rejected. And if it's rejected, again, you can request for re-examination, and then it goes through all the way to the end, which is the second instance, the Supreme Court. But let's say your application is issued, anyone and any time after a patent is granted can request invalidation, and they go to patent re-examination and invalidation department to do that. Their decision is again appealable to court, Beijing IP Court as the first instance, and then the Supreme Court as the second instance. So some details, really here and there, pieces of key tips I will be giving. First of all, novelty standard. You need to understand China has an absolute novelty standard, which means any type of disclosure in anywhere in the world will be novelty destroying. And the definition of disclosure is different from the US. In the US, they have on sale bar. In China, there's no such thing as an on sale bar. A sale, a lease, exhibition, even a public use is not necessarily a disclosure. For example, you display a big equipment, there's some invention hiding inside the box, and nobody have access to it. Even you have the machine running, nobody can see what makes the machine running, what the true invention, how is it executed. That's not a disclosure of the invention. So the ultimate standard is the technical solution you're trying to patent must be in the public domain for it to be novelty destroying. Being in public domain means it is in a state where it is accessible to the public. Public meaning non-specific third person, non-specific person. So for example, if I'm giving out a presentation in a room in a hotel with no guards, anyone can walk in. I'm giving out the technical solution. So the technical solution will be in a state that is accessible to the public, but the result is no one actually came in to listen to my presentation and get access to this technical solution. But that will still be my presentation. Giving out this technical solution will still be considered novelty destroying because that technical solution is in a state where it is accessible to the public. But let's say if you sell your product, it's locked, you sell it to public, anyone can buy it, and then they reverse engineer it so that they can know the technical solution, that will be novelty destroying. But a secret sale to a specific person, not just anyone, with ideally with a confidentiality agreement in place, that will not be novelty destroying. So that is quite different from the US standards. So it has to be approached case by case. There is indeed a grace period in China, but my recommendation in short is don't rely on it because it's very limited. The new law says only under these 4 circumstances can you use the grace period, and it's only 6 months. First, if there's a national disclosure due to national emergency, and second, if it's first disclosed in an international exhibition organized or recognized by the Chinese government, that sounds good. But if you really look at the detailed rules, there may be only 1 or 2 international exhibitions that actually meet the standards. So most of them don't. So don't rely on it. Prescribed meeting and technological meetings, these are only usually referred to meetings inside China. Or if it's disclosure by others without consent of the applicant. We in the past have used this provision a couple of times, have been successful. So if you can successfully prove that, that's good. But keep in mind that even if it gives you a grace period, it's not equal to priority. It still creates priority for others. I'm not going to elaborate on that. And PCT national phase in China, you need to keep in mind that we have 2 extra months available. So usually the date is 30 months from the earliest priority date. But if you pass that date, don't panic. You need to do nothing by 30 months deadline. You automatically get 2 months extension. All you have to do is to enter the national phase by 32 months deadline. And there will be extra fees. But national phase entry, you need to submit Chinese translation. There is no later supplemented translation. So by the time you take the action of entering national phase, you need to submit the Chinese translation. And funny thing about national phase in China is that there's no way for you to save any fees. This is, as far as I know, different from any other country. So let's say you want to reduce your access claim fees, like in Europe, it's extremely expensive. You have 100 claims. When you have this international publication, you want to reduce it to 10, which is free in China. You have to pay from the 11th. But you will not be able to do that because in China, the access claim fees is calculated based on the international publication. You still have to pay 100 minus 10, 90 access claim fees. There's simply no way to reduce that cost. So that gives you a hint that maybe when you file the application, don't abuse, just keep your number of claims as reasonable as possible if you ever want to enter China. A good thing about PCT application is that you can actually correct any translation error because the original disclosure is the foreign language version as filed, not the Chinese translation. In contracts, if you filed in China through Paris Convention, you may not be able to do that because the Chinese translation that we filed is the original disclosure. You cannot rely on the priority application, which is in the foreign language, to make any amendments. But this will change. I will get to that. Expedited examination in China, there's no formal way to do that. Usually we request for substantive examination at the time of filing and request for early publication at the time of filing. Then the application will enter substantive examination stage as soon as it is published. But there is a PPH agreement available with, I believe, around 30 offices around the world, so we can take advantage of that. But very strict formality requirements, timing has to be right, substantive claims have to be right, formality has to be right, very typical Chinese way. Everything is strict. Another tip for you to prosecute Chinese application is that you only get 2 chances to file voluntary amendment. The first one is at the time of filing substantive examination. You can amend your claims, you can amend your description. And the second chance is that after you file substantive examination request, you get a notification from the patent office saying the application has entered substantive examination stage. Then you get 3 months window to file as many voluntary amendments as possible. The latest one would be the basis for examination. But once you pass that 3 months window, there's no way to file voluntary amendment. You can simply not file voluntary amendment in response to an office action. Basically, that means you cannot enlarge scope of protection after you receive an office action. You cannot add new independent claims. You cannot swap a new set of claims. You cannot even add new dependent claims. Basically, keep in mind that once the examiner has done the search, issued an office action, he or she simply don't want any extra work. Keep that in mind, and that's why they don't allow you to file any voluntary amendment. Another key point is a divisional application. This is also important. There's no restriction on what you can file in the divisional application. As long as you don't go beyond the original disclosure, there is no restriction on the number of divisionals you can file or number of generations of divisionals you can file, but there is a deadline. The deadline is 2 months from you receiving the notice of grant from for the mother case. So you have a mother case, is granted, you receive notice of grant, you have 2 months to file divisional applications voluntarily. So you can file first generation, you can file second generation from the first generation, but as long as you are within that 2 months window, you're fine. But once you pass that 2 months window, no voluntary divisional applications. So my suggestion, our suggestion is usually when you file a divisional application and you know that you may want to file further divisional applications, you make that first generation of divisional application lack of unity intentionally. Basically, we throw in a set of claims that simply don't have any unity with the set of claims that we want to pursue. In this way, the examiner will point out the non-unity defect in the divisional, in which under that circumstances, you can file further divisionals. Otherwise, if your divisional is perfect in terms of unity, then examiners will not issue any office action against the unity, then you lose your chance to file further divisionals. So my next point is about foreign filing license. A lot of people are under the impression that if you have an invention made in China, you need to first file in China, and that is not true. What is requires that if you have an invention developed in China, before you go ahead and file in another country, you need to get a foreign filing license. We call that security examination for filing overseas. Let's call that foreign filing license. You need to get that foreign filing license from the Chinese Patent Office first before you are allowed to file in another jurisdiction. It does not go with the inventor's citizenship. It does not go with where the inventor is residing. It goes with where the invention is developed. For example, if a US citizen comes to China and develops an invention in China, the Chinese foreign filing license requirement applies. But if a Chinese citizen goes to the US, makes an invention in the US, the Chinese foreign filing license requirement does not apply. But let's say you have a joint invention. It's made in cyberspace between a US inventor located in the US and a Chinese inventor located in China. It's prudent to fulfill the requirements in both countries. In China, this foreign filing requirement only applies to utility model or invention, not to designs. It is a ground for rejection and invalidation. The penalty is that you won't get your Chinese patent. So if you don't care about your Chinese patent, then that's fine. Unless you divulge a national secret, when in that case, then criminal sanction will step in. So how can you get that foreign filing license? You can either file a separate request for foreign filing license without filing anything in China, or you can simply file your Chinese application at the same time, or after that, request for foreign filing license. Or you can, for many multinational companies, they choose the third way. They file a PCT international application, and that application itself is deemed as a request for foreign filing license. You don't have to separately file a request for foreign filing license. And the good thing about this is you can file a PCT application in English, either Chinese or English. And that's easier for the in-house attorneys or foreign counsels to understand what is being filed. Keep in mind that in China, as long as you don't file before you get Chinese foreign filing license, you do not violate anything. So make sure that you get a foreign filing license in China before you file. Say you can get a foreign filing license in the US without filing a US application, and then you get your Chinese foreign filing license. In this case, you fulfilled the requirements in both countries. Next thing about design practice, now we're allowing partial designs. So for something like this, like part of a shoe, you can disclaim other parts by using dotted lines. So that is allowed as of June 1st. The design patent term is extended to 15 years. There is still no shading allowed in China. You can put in multiple designs in one application, but they must be similar. You can put in up to 10. The following slides are directed to proposed changes. I'll go through them very quickly. First of all, to restore an invention, to restore an application. If you missed the priority, currently it is not possible, but in the future it will be. You can restore priority if you forget to, or if you forget to file the application by 12 months deadline, you get 2 extra months. Same for PCT. If your international application date is within 2 months from the priority date, you can still restore priority at the time of entering national base. This is not possible yet. This is only included in the draft implementing regulations. And correcting or adding priority, if you forget, say you file the application, but you forget to claim priority, now you can have up to 16 months from the earliest priority date, or 4 months from the filing date. For a design application, now you can, now it's made very clear that you can actually claim priority from an earlier invention or utility model based on the drawings. And incorporation by reference, as I said earlier, for PCT application, the original disclosure is the foreign language version as filed. For Paris Convention application, is the Chinese translation as filed as the original disclosure, but these may change after this new rule came into place. The new rule said you can use incorporation by reference of the priority application. If you file your application, you missed the whole part of description or the whole part of claims, one of them, not both. You can use incorporation by reference of the priority application and get this back into your application. So the priority application serves as the original disclosure in this case. And you have 2 months from the filing date to do that. If you miss some parts of the description and some parts of claims, you can also do that by taking advantage of the incorporation by reference. And that applies to PCT national base as well. So with that, I conclude my presentation. These are the 2 books I authored. You can search them online, and the blue one is free online. Thank you very much. I will conclude my presentation right here. How do I stop? Okay, great.
Thank you very much, Mr. Yang, for such an enlightening presentation. Moving on to our 4th speaker, Ms. Elizabeth Berthe, partner of Promac Law Firm from Paris. Ms. Elizabeth, with her dual training as a doctor in pharmacy and as a lawyer, has more than 27 years of experience in the field. Ms. Elizabeth provides advice and handles litigation in the field of medicine, medical devices, cosmetic products, foodstuffs, and agri-food. In particular, she manages important patent, SPC, and trademark litigation involving major pharmaceutical groups. Her knowledge of the pharmaceutical industry also makes her a preferred interlocutor in matters relating to the regulation of medicines and borderline products, where she assists her clients before the European and national health authorities and represents them before the administrative courts. Ms. Elizabeth also manages all types of contracts relating to pharmaceutical activities. Over to you, ma'am.
Okay, perfect. Thank you very much. So I'm going to share my screen. Sorry. Okay. So here, like that. Oh. Okay. So thank you very much, first of all, for inviting me to this webinar. So I'm going to speak about patent in France, and with the example of the pharmaceutical industry, because I handle a lot of case for life science industry. But this example is, of course, enforceable to other fields. So more precisely, I'm going to describe the use of patents in the competition between innovative and generic companies. So what are the tools used by the patentee? First tool, the evergreening strategy. Second tool, the divisional application before the European Patent Office. My Chinese colleague has already speak about this very interesting topic. And third tool, of course, the infringement actions before the courts. So first patent tool, the evergreening strategy. What is this strategy? It consists in filing numerous patents, up to 1,000 sometimes, on the same product, this patent being staggered over time. So you first have the first patent on the original active principle, then the patentee several years after file other patent on new derivatives of this active principle, like different salt or isomer. Several years after, different patent on galenic forms, usual tablets, for instance, sustained release tablet, patches, and then you have the same principle which apply with therapeutic application patent, processes for synthesis patent, dosage, etc. And at the end, the monopoly for the patentee lasts well over the usual duration of 20 years. And as it is mentioned on the graph, you see for the example of omeprazole, the author concluded that it was protected for 35 years. And this postponed, of course, the freedom to operate for the competitors. Moreover, this evergreening strategy creates a real labyrinth and a legal uncertainty for third parties. So it's very difficult for the freedom to operate research to find a domain which is free to operate. And this prevents generic and biosimilar from launching their product, or at least this delay their arrival on the market. It's worth noting that this strategy is particularly relevant when it's combined with the switch strategy. The switch strategy consists in the fact that shortly before the first patent expiry on the first generation product, for instance, the usual tablet to be taken twice a day, the innovative company launches a second generation product, for instance, a sustained release tablet to be taken only once a day, which is in turn patented. And in fact, it encouraged a doctor at the same time to switch their prescription from the first generation product, no longer patented, to the second generation product, which is still protected. And therefore, we understand that when the competitors enter the market with the copies of the first generation product, the only which is available for them, the market is extremely reduced, and the innovative company managed that way to keep a monopoly on an important part of the market, thanks to the second generation patented product. Okay. Oh, sorry. Okay, so here are some examples of such a combined strategy, but there are many others. Second patent tool used by the innovative company is the divisional applications before the European Patent Office. So let me make some preliminary comments. First point, for competitors, as you know, legal safety, or at least assess risk, is essential before launching a product, and especially in the pharmaceutical field where the interests at stake are very high. And the legal safety, in fact, takes place when the competitors know what protection they have to face. That means when the patent is granted, because the scope of the patent as granted can be very different from the scope of the patent application initially claimed, which is generally broader. And also when the potential third-party opposition proceeding before the EPO is completed. Because following such proceeding, the scope of granted patent can be limited, or the patent can even be revoked. Second preliminary comment, the usual reason for filing a divisional application, it's when the initial application does not satisfy the requirement as to the unity of the invention. the fact that one patent should correspond to one invention and not to several inventions. And when it's not the case, the patentee has to split its initial patent application into several divisional applications so that the unity of the invention is respected. But apart from this original use of divisional application, there is misuse of such application by some company so to prolong the legal uncertainty for competitors. Why? Because each divisional application will give rise to a new examination, potentially to a new opposition proceeding on this divisional. And during this time, the competitors still don't know what protection they will finally have to face. And in fact, the system is endless because divisional applications may in turn be the subject of their own divisional application. And you understand that this delay competitors from launching their product for a long time, more precisely until they have legal certainty about the scope of the granted patent corresponding to the divisional application. Third point, the infringement actions before the court. This action can take the form of preliminary injunction proceeding or infringement action on the merit. And I will discuss lastly on the defense of the competitors. So in France, you can launch a preliminary injunction proceeding. The purpose is to quickly withdraw and recall the competitor's product from the market, and also sometimes to obtain a provision of damage. The duration of such proceeding is quite quick, 5 to 6 weeks, and sometimes you can have very urgent proceeding which lasts only a few days. I remember a case I have handled for Sandoz several years ago, and we were sued, I remember, during the summer, the 26th of July. We have pleaded 5 days after, the 1st of August, and we obtained the decision, fortunately, in our favor, the 10th of August. So you see that we can have very, very urgent proceeding in France. Second type of proceeding, the infringement action on the merit. Here, the main purpose is to obtain the full compensation for infringement, but such action is really longer than the first one. It's around 2 years in first instance and the same in appeal. I draw your attention on the fact that the French courts are more and more inclined to give high damages for the patentee, even in the course of preliminary injunction proceeding. You can see that several millions of euros are sometimes ordered. So what are the defense of the competitors against such infringement action? Two main defense. The first one is to claim the nullity of the patent. As you know, the granting of a patent provides a simple presumption of validity, but the patent can be challenged and revoked before court. The main argument to challenge a patent is the lack of novelty, the lack of inventive step, and the insufficiency of disclosure. And second argument, it's the non-infringement arguments. It's when the competitor's product doesn't fall within the patent claims, usually when the patent claims are narrow. So let's go into a little bit more detail concerning these arguments. So nullity of the patents. You can claim the lack of novelty of the patent because the patent is valid if the invention is new. That means if this invention is not part of the state of the art, and the state of the art being defined as everything that has been made available to the public before the date of filing of the patent application, anywhere in the world, so it's an absolute novelty, and by any means, publication, conference, trials, etc. It was nothing that novelty of the patent doesn't mean necessarily novelty of the active principle, but the novelty can take different form. For instance, the novelty of a galenic formulation, even if the product per se is already known in the prior art, for instance, in the form of tablet, you will be able to obtain a valid patent if you want to protect a patch which was not known in the prior art. The same for a new therapeutic application not described in the prior art. What about the inventive step condition? Here also, if the patent doesn't involve an inventive step, it can be revoked. And an invention involves an inventive step when it's not obvious from the prior art, according to French law. So let me give you two examples. First example, assuming a product of formula A is known as being an anti-migraine, a patent has been granted on a product A1, which has a formula very close to A, also as an anti-migraine. Is it obvious or not? Is the patent valid or not? Apparently, the patent could be revoked because since A1 and A are very close, it was obvious for the man skilled in the arts that A1 was also an anti-migraine as A. On the contrary, second example, if none of the anti-inflammatory products have ever been described in cancer treatments, and you discover that a specific anti-inflammatory has anti-cancer activity and you file and obtain a patent, apparently this patent is valid with respect to inventive step because it was really not obvious for a man skilled in the arts. A last element on this point, the insufficiency of disclosure can be put forward to revoke a patent. It's not a condition of patentability per se, but it can be used to nullify patents. According to French law, an invention should be described in a sufficiently clear and complete manner for a person skilled in the art to carry it out. The fact that this requirement is based on the fact that the patent system is an agreement between the patent holder and the society, the first one receiving a monopoly in exchange of the enrichment of the state of the art. And if the enrichment is not there, if the patentee doesn't respect his duty to enrich the art, he cannot obtain a monopoly. And several patents are revoked on this ground for many years now. For instance, patent with too broad claims, so be careful with too broad claims patents. Also patent with insufficient tests to support the invention. In that case, the court called this patent the speculative patent because the patentee has speculated and has not really provided sufficient tests. And specifically in the pharmaceutical field, you can also nullify a patent. I have nullified 2 patents quite recently on this ground, dosage patent with no improvement compared to the previous dosage. And in that case, the court has considered that these patents do not bring, in fact, a real technical contribution. So you see that regarding this specific point, insufficiency of disclosure corresponds, in fact, to insufficient technical contribution to the art. Second main defense against an infringement action, the non-infringement argument. So in France, you should keep in mind that the infringement relies on the following main principles. First one, very important, the infringement is assessed according to similarities and not to difference. So it's useless to say, but my product is different because of that, of that. What is important are the similarities. Second principle, perfecting is infringing. And third point, very important also, is that alongside literal infringement, which enable to forbid strict copies, there is also infringement by equivalence, which enable to include really more elements. It's an infringement by means of different forms compared to the one patented, but performing the same function for a similar results. Last slide with some examples where the non-infringement argument has been put forward. What is important to keep in mind is that, but I guess it's the same outside France, unfortunately, but there are sometimes some inconsistency between the decision. If I take the example of the two last decision on this slide, the facts were very similar. In the two cases, the claims were very narrow and protected only a derivative, a specific derivative of a pharmaceutical product. The generic company used in the two cases a different derivative. In the first case, AstraZeneca, the generic company has been judged as not being infringing. And in the second case, Fresenius, it has been judged as being infringing. So it's very difficult to give a clear guideline in France, but I know, unfortunately, once again, that it's the same outside France. So thank you very much.
Thank you so much, ma'am, for such a great presentation. So now moving forward, now the forum is open for discussion and the questions raised by the participants and also our panelists are eager to answer your raised question. The question raised for Mr. Wagner and Mr. Lester have been already answered. So one of the question has been raised for Mr. Stephen Young. Yes, sir. What is the rejection ratio approximately in China, looking at the enormous number of filing of patent application?
Shall I answer it now or put it in the chat?
You can, sir, answer in chat box also, or you can answer it.
Okay. This figure changes quite often, but last time the office actually released this figure, we can actually calculate the issue rate is only 44%. So very low patent grant rate. But that, of course, includes a lot of what we call abnormal applications, junk applications. Yeah. So that is my answer.
Thank you, sir, for your answer. And now there's a question for Ms. Elizabeth. How do you manage the multilingual filing from different parts of the EU at the EU IPO?
Sorry, excuse me, could you repeat, please?
Yeah, sure. Ms. Elizabeth, the question for you is, how do you manage the multilingual filing from different parts of EU at the EU IPO?
In fact, I don't file patents. In fact, I'm not patent attorney, so I don't deal with the filing of patent at the EPU level. I'm sorry. I litigate and I give advice, but I'm not patent attorney. I'm really a lawyer. So all the prosecution, in fact, it's not my day-to-day work.
I guess maybe Dr. Wagner can answer that.
Yes, so there's three main languages. It is German, English, and French. We need to translate all the claims to these 3 languages in the end when we have the decision to grant. Before that, we have some London agreement to solve the language problem, and it is quite expensive and quite complicated. We would really need to have a look what is the first filing language and where do we want to validate in the end. And this is something that is getting easier as well when we will have the unified patent available soon.
Thank you, sir. So now I request Mr. Nitin Patel to appraise this gathering with his vote of thanks. Mr. Nitin is a patent agent and works with the patent division of HK Acharya and Company. He holds a bachelor degree in electronics and communication from Hemchandra Acharya, North Gujarat University. His principal focus is around the patents identified with electronics and communication. He is engaged with prior art search, drafting the patent application and replying the office activities. So now I request him to deliver a vote of thanks.
Thank you very much. Ladies and gentlemen, it's my privilege to deliver the vote of thanks to all the dignitaries and participants at this webinar. In the light of the fact that the technology has become very dynamic and with engineering playing a major role in the metamorphosis, I am sure you all must have found the webinar to be very useful and enriching with a lot of takeaways. First of all, I would like to thank markpatent.org for having organized this webinar on an important subject in today's context. Welcoming the participants, Mr. Omkar Acharya, trustee of markpatent.org, talked about exponential growth in the engineering sector post-dynamic leading to small and big innovations, and thus opening the door for the patent registrations. Thanks, Mr. Omkar Acharya, for that wonderful welcome address. Mr. Lister Miller, Principal, Foundry Intellectual Property Australia, said patent ownership boils down to what a person wishes to do. He also stressed the importance of timing filings. He took us through the developments of the design patents in Australia. He narrated the case between the gaming company and the Commissioner of Patents. Thanks, Mr. Miller, for giving practical insight of your presentation. The next speaker, Dr. George Wagner, patent attorney, Triad Patent Germany, spoke on how to secure artificial intelligence in Europe and about know-how protection in Germany and the European Union, including UK. He also gave details about digitalization of intellectual property and listed the different categories of artificial intelligence inventions. Dr. Wagner very strongly recommended the drafting of the full specification so as to give clear search. He even spoke about the possibility of grant of unitary patents by this year end. Thank you very much, Dr. Wagner, for that enlightened presentation. Next, I would like to thank Mr. Stephen Young, Managing Partner and Patent Attorney from IP Mark China, for detailed presentation on the basis for the patent practice with content such as law and implementing regulations. He also explained by way of a flow chart the patent application procedure in China. Mr. Young also gave details about the PCT, national phase entry, foreign filing license, restoration of patent rights, and claiming priority in China. Thank you, sir. Ms. Elizabeth Berthet, partner Promark Law Firm, Paris, spoke at length about the use of patents in competition between innovative and generic companies, and also explained in detail the various actions before the courts. Ms. Elizabeth also explained the grounds by which the competitor may nullify the patents. Thanks, Ms. Elizabeth, for giving an exhaustive talk on the injunction proceeding and infringement actions with example to support. Thank you, ma'am. I would be failing in my duty if I don't make a mention of the continuous support we have been received from our co-organizers. Gujarat Technological University, Institute of Law, Nirma University, Loyola Center for Research and Development, ICFAI Law School, Hyderabad, USIIC School of Law, Gujarat University, LD College of Engineering, and Rotary Club of Ahmedabad Elite. A big thanks to all the organizers. Last but not the least, thank you all viewers for taking time off and participating in this webinar and making it a grand success. This is Nitin Patel signing off. Have a wonderful weekend ahead. Thank you very much.
Thank you, Mr. Nitin, for that wonderful vote of thanks. In closing, I wish to express my gratitude to all the panelists and participants for the full cooperation. It offers me a chance to commemorate our success in pursuing excellence in the field of IPR.
We are privileged to have in attendance such distinguished experts as well as observers. Having such resourceful and knowledgeable panelists which have helped us gain insights on engineering and advanced concepts of patenting in IPR. So thank you, everyone.
Thank you for joining us, ladies and gentlemen.
We wish everyone to stay home and stay safe.
Thank you. Bye-bye.
Thank you.
Thanks, guys.
Thank you so much.